to sentencing. The first thing that the court is going to do is go through the fines, and this is required in every case. The court is going to impose a $40 court operation fee and a $30 criminal conviction assessment fee on both counts 1 and 2. Court is also going to impose a $300 state restitution fund fee, and the court is also going to impose a $300 revocation fine. The latter is stayed pending successful completion of either probation or parole, if that were to occur. With respect to the credits, the sentencing report does indicate dates up to today, and the court indicates that it will then put in the abstract or in the minute order 1,042 days of actual time, as what was pointed out by the people. Because of the conviction of murder, there are no conduct credits. Would the defense agree with that? All right, on behalf of the people, do you have to take issue at all with the number of days of actual time in custody?
No. Thank you.
All right, now let's go to the next area, and that is restitution. The probation department said to be submitted later. However, the people did submit a restitution order, and I think that has to do with reimbursement of the victims' compensation fund. Am I correct on that?
Yes.
Is there any other restitution other than what you have put in the restitution order?
We have reached out to both Aiden's father and mother, and they both declined any further restitution.
Well, what the court's going to do, my tentative is to execute the restitution order as submitted and reserve jurisdiction in the event that there is further restitution having to do with the impact of the crime. All right, any issue with that on behalf of the defense?
No issue.
Okay, now we go to the actual sentence. The actual sentence. The first thing that the court should do is to impose the sentence on count 1. The court, at this point in time, will impose 15 years to life on count 1, which is the punishment authorized by the statute. The court will now go to the enhancement. And as I've attempted to articulate, if the court dismisses the enhancement, the court then goes back and determines if the defendant is statutorily eligible, and I will revisit the sentencing on count 1. So the issue for the court today, and I think everybody has agreed, is whether the court, in its discretion, should strike the additional 25 years to life under 1222.53. The court in that has considered the defendant's statements, considered the report that was authored by the doctor that was submitted to the court yesterday. I've considered the fact that the report does indicate childhood trauma, and I've also considered the fact of the age of the defendant at the time. And before I get into the final decision, I'm assuming, as the people brought out, the court is making the report of the doctor as part of the sentencing, so that this constitutes a Franklin hearing, and the defendant has had the ability to set forth the factors in the event that that becomes important in the future. But I just wanted to make sure, are there any other information in terms of the Franklin hearing that the court is required to conduct at this time because of the age of the defendant at the time of the sentencing, at the time of the offense?
The only defense request I have specific to the Franklin issue is that there is some law that indicates about what the defense ability to reintroduce Franklin factors after the court sentence as we're going to our parole hearing. And I would simply ask that if new information that is available, that defense retains the right to introduce that to the extent that the law allows that. I don't think that's really a concern for the court today. But other than that request, no.
All right, you paid the record on that. People, you wish to be heard on that?
No, Your Honor, thank you.
All right, so now let's get to the factors that the court has considered and exercise in its now discretion to whether to dismiss, strike the 12022.53. As I've indicated, I've taken into account what has been reported is the childhood trauma of the defendant. I've taken into account the age of the defendant. I've taken into account also the defendant's statement here. I just cannot draw a connection between the childhood trauma, what has been reported about the lack of development of frontal lobes of individuals at that age, as well as his age, and in looking and reading and presiding over this case, this defendant didn't commit any crimes until this particular day. He didn't. He's driving on the freeways. He's being subject to, I think, what we all see every day. And there was no impulse other than on this particular day. And I just can't connect that in this case, that his childhood trauma or his age was a factor in the commission of this crime. We have a 6-year-old in the back seat, the most vulnerable victim that you can even imagine, going to kindergarten, being driven by his mom. And she, the mom, did some driving maneuver that caused girlfriend to give the peace sign, that caused the mom to flip off, and that caused you to get behind the car. And in that particular moment, you had the power. And the power was that handgun. And whether it was to impress your girlfriend, to release your anger, you fired. And that little boy died. When all is said and done, that's what happened in this case. I cannot, as a sentencing judge, look at the facts and circumstances of this case and see any stretch of the imagination, a non-legal justification such as being provoked or anything other than I'm going to get back at her. And that's what happened. And as the people have brought out, and there's a case that our United States Supreme Court decided almost 30 years ago called Payne versus Tennessee. And what is an aggravating factor of a crime is victim impact. I don't think the English language can even attempt for anybody to even describe what Aiden's mother went through after he said, ouch. She pulls over and her little boy dies in her arms. I don't think anybody can even comprehend what the rest of her life is going to be how her little boy died. The court places great weight on that aggravating factor that I'm allowed to do. And as a result, the court, in exercising its discretion, will not dismiss the enhancement. The court will impose 25 years to life consecutive to the 15 to life for count 1, for a total of 40 years to life. With respect to count 2, I'll ask the people. I do agree with the defense. I think the people also perhaps share in that it is merged pursuant to Penal Code Section 654. Would you agree?
I do, sir.
So the court is still required to impose a term. The court will impose and follow the 1385 now, because there was not a submission of factors of aggravation having to do with count 2. Am I correct on that? On
You
behalf
are,
of the people? All right. So the court then, in exercising its discretion under the California Rules of Court, will impose the midterm of on that, and the court will also impose the 25 years to life, but it will run, it is merged pursuant to Penal Code Section 654. Now, before I get to the final order to the sheriff, I do want to ask, the court's having, does the people see any sentencing errors that the court has made in terms of the imposition of the sentence?
No, Your Honor.
On behalf of your client?
No.
If I can have just a moment. You think anything else before I give the appeal rights to the sheriff? Okay. Sir, I need to address you. You have a right to appeal the sentence of the court. And this is very important. I need to know that you understand this. It is your responsibility to file the notice of appeal. You must do so within 60 days. It must be filed with the clerk of my court here. It is your responsibility. I'm sure you've discussed that with your attorney. If you do file a notice of appeal, the appellate court will do 2 things. They will appoint an appellate lawyer for you at no charge, and you will also be provided a transcript of the necessary proceedings. What's important, and I want to make sure you understand this, is that it is your responsibility, and your attorney can do it, but it's your responsibility to file the notice of appeal within 60 days today. Do you understand?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right, anything further on behalf of the defense in terms of the sentencing or the notification of the appellate rights?
No.
On behalf of the people?
No, Your Honor.
All right, the sheriff at this time is ordered to transport the defendant forthwith to the Department of Corrections. Court's in recess.
Thank you very much.
Yeah.